When a Queensland developer novates an architect's contract to a D&C builder, the legal landscape shifts overnight. Here are 4 key points every design professional should understand. First, novation is not assignment. Novation doesn't just transfer rights. It substitutes an entirely new contractual relationship for the old one. That means the deed itself needs to deal expressly with accrued rights and liabilities and with how pre-novation services are treated going forward. If the deed is silent on those points, the architect may be left with real uncertainty about who can make claims for what and when. Second, watch for the ab initio trap. An ab initio novation deed treats the builder as though they had always been the client, right from the start of the architect's engagement. If the original consultancy terms haven't been reconciled with the builder's D&C contract before you sign, pre-novation services can be exposed to elevated contractual standards, including obligations that may fall outside your PI cover. Third, proportionate liability has limits. Queensland's statutory apportionment scheme for apportionable claims cannot simply be excluded by contract. But that doesn't mean you're fully protected. Separately drafted indemnity in the novation deed can still create additional contractual exposure depending on its wording, even though the apportionment regime itself remains intact. Fourth, compliance is still your responsibility. A builder's value engineering demands do not displace the architect's compliance obligations, professional duties, or the need to act within the authorized scope of services under the novated contract. If an instruction would compromise compliance, it should be refused in writing, regardless of the commercial pressure. Each of these issues turns on the specific terms of the deed and the circumstances of the project. If you're facing a novation, get tailored legal advice before you sign.